depend on it. When the Prime Minister thought, who should I buy them from? He looked around the world and he said, I know.
Ultimately, it is up to the committee to determine whether it is satisfied with the documents provided in response to its order. With that, I would be pleased to answer your questions. Thank you.
Okay, thank you, Mr. Dufresne, and we will go to the question 6-minute round first. The lineup is Mr. Poilievre, Mr. Fragascatis, Mr. St. Marie, and Mr. Julian. Starting with Mr. Poilievre. The floor is yours, Pierre.
Thank you, Chair, and thank you, Clerk, for your broad context. Now we'll get down to some binary yes or no questions. Did the government provide you, did the government provide this committee with all of the content the committee requested in its original July 7th motion?
The information that was provided excluded cabinet confidence information and included information that was found to be not relevant, so beyond the scope of the initial motion.
Sorry, I think you might have misunderstood the question. I'm not asking about what you received. I'm asking about what the committee has thus far received unredacted. Has the committee received all of the information that the committee requested in its July 7th motion?
It has received what it has asked for, with the exception of the redactions that I've highlighted on those categories under the access to information legislation that the committee did not include as valid grounds in its motion.
And the Access to Information Act exemptions and exclusions, do they apply to requests by Parliament for papers and records?
They do not apply to those requests unless the committee decides to include those grounds in its motion.
Did the July 7th motion allow those grounds for exclusion or redaction?
It included the ground of cabinet confidence, but not the ones that I've listed: third-party information, information on vulnerability of government's computers, solicitor-client privilege, and consultations. Those were not included. Personal information was included, but it was meant for my office to redact and not the government.
Okay. So then, again, did the government provide the committee with all the information the committee requested in its July 7th motion?
No, because it invoked those grounds that the committee did not allow.
And those grounds are not legally legitimate. Okay, so the next question is, the government has excluded documents on the grounds of cabinet confidence. Can you confirm, yes or no, whether the government accurately applied the grounds of cabinet confidence?
I cannot confirm that, Mr. Poilievre. I have not seen behind those redactions. The motion in November provided that those redactions could be kept by the government when it sent me the new package.
Right. So we don't know one way or the other whether or not those exclusions are properly applied. How much time do I have, Mr. Chair?
You've still got about 4 minutes.
3
minutes. Sorry, Pierre. 3 minutes.
On a related matter, Mr. Dufresne, you are the chief legal counsel to Parliament. You know its powers better than anyone. Your office sent me a briefing note today telling me that the power of Parliament to send for persons is part of the privileges, rights, and immunities of the House of Commons, which is inherited when it was created and are found in Section 18 of the Constitution Act 1867 and Section 4 of the Parliament of Canada Act. Now that in the related committee, Ethics Committee, the Kielburger brothers has refused to appear and refused an invitation from Parliament, can Parliament issue a summons and force them to appear before that committee? And if they still refuse,
order relevance. Point of order, Mr. Chair, relevance.
I see the government's very sensitive about this, and
No,
they'd like
it's
to
just
cover up
relevance.
this conversation. We'll let
Not at
Canadians
all.
decide what's relevant.
Oops, sorry there. What's your point of order?
Thank you, Clerk, for your broad context.
We are here to have the law clerk testify before us about the compliance or non-compliance with the July 7 motion.
The country that's holding our people hostage. You can imagine the PRC Politburo filled with bureaucrats rolling around on the ground in gut-splitting laughter at this Prime Minister's naivete. Madam Speaker, simple question. When he wasted 100 days in the PRC, what the hell was he thinking?
I'm not quite sure what the relevance is as to bringing in the we and whether the heads of the we organization are going to be coming before the ethics committee.
Point of order.
I am going to allow the discussion because the discussion is with the law clerk here. I think pretty near any question that relates to the legality of what committees can do would be relevant in this discussion with the law clerk. Your point of order, whoever it was it Mr. Falk or who?
No, it was.
Sorry, Mr. Julian.
Mr. Julian, thank you, Mr. Chair, and you're absolutely right. The subject today is compliance with committees, and so your ruling is absolutely appropriate.
Okay, back to you, Mr. Poilievre. I've lost track of time. I think you got 2 minutes and a half left.
If the Ethics Committee makes a summons for the Kielburgers to appear and they refuse, what law enforcement powers can Parliament order in order to compel testimony?
So in the situation where a summons is issued by a committee and the witness continues to refuse to appear, the committee does not have enforcement powers itself, but it would need to, if it chose, report the matter to the House. And the House would then consider it under its authority.
And the House, and if the House were to decide that the Kielburgers had to testify, what enforcement powers and enforcement bodies could it use to do so?
The House could consider the matter in terms of issues of contempt of Parliament. It could consider the matter in terms of summoning individual to the bar of the House and to explain the refusal to appear.
And if they refuse to come to the bar of the House, what then? What powers then would the House have to compel them to appear if the House so wished?
Well, this is discussed in procedures and practice in terms of censure, reprimanding, summoning individuals to the House. The House would consider whether could consider whether it's a contempt of its privileges and make a finding to that effect. Historically, there has been the authority to summons and issue a warrant to bring an individual into custody and bring the individual to the bar of the House. That has not been done in Canada since 1913, and the circumstances are discussed in procedure and practice. So it's not something that we see.
So the last question, Pierre.
So to conclude, we've got confirmation the government did not provide the committee, with the documents that it requested in its July 7th motion, that the law clerk has no way of knowing if the government has been honest and forthright in its use of the cabinet confidentiality exemption, and the hundreds of pages of information that are covered are excluded on that basis may or may not be cabinet confidentiality, and that the House has legal enforcement abilities to compel testimony from the Kielburgers. So that is a summary of what I think we've just heard. I want to thank the law clerk for appearing here today and for his work.
And we will give the law clerk the opportunity to respond to that statement. Mr. Clerk, Mr. Dufresne.
Well, I think I've given the answers. I think to the questions, in that there were grounds that were invoked that were not included in the motion with respect to the cabinet confidence. I have not seen those. The motion in November did not provide that I would see behind those cabinet confidences. And in terms of the the House's powers, those are set out in procedures and practice and include those elements that I've listed.
Okay, thank you both. Mr. Fragiskatis, Peter, 6 minutes, followed by Ms. Gill, sorry.
Thank you, Mr. Chair. Thank you, Mr. Dufresne, for being here. I want to ask you a question relating to the law and principles that underpin our legal system. Are you of the view that solicitor-client privilege is fundamental to a legal system in a democratic society?
I am.
Okay. I point this out because in your remarks, you stated, and I wrote it down here, so I'll just read it for the record. Some of the government's redactions are based on grounds not contemplated by the July 7th motion, which is the part that Mr. Poilievre heard. I acknowledge that that's the part he heard. What he, it seems, did not hear is the rest, where you said, but that are rooted in the Access to Information Act. You mentioned solicitor-client privilege. You've affirmed the importance of the solicitor-client privilege to our legal system in Canada. There's other examples that you give, including personal information, which, you know, and I put this to my colleagues on the committee. I think it's very important that the personal information of public servants and other third parties is protected, unless Mr. Poilievre wants the cell phone number of certain public servants or email addresses so he can call or email them. I'm sure he's up to it. I'm sure he would do that, but I don't think that's really important. I think that that information is protected. I know it's protected under the Access to Information Act, which is a critical thing. Mr. Chair, I'll continue here. Would you, Mr. Dufresne, have made the same redactions?
I would have.
If it was up to you.
Well, if the committee allowed those grounds, and that's how I concluded my remarks.
Let me put it another way. Were the redactions consistent with the Privacy Act and other relevant acts?
They were, in my view, consistent with those acts and those definitions. And so, again, if the...
Anyone? I mean, it's just $250 million. I mean, what's that between friends, right? Anyone? Any data? No?
Thank you, Ms. Rampel-Garner.
Thank you, Chair.